Good evening and welcome, everyone. We are so happy to have you here with us from the East Coast to the West Coast. We're glad you're joining us. I'm Tara Secreta Parker. I'm the CEO and co-founder of Prime One Sports. We are a sports agency located in the Washington, D.C. area, and we are focused on educating, empowering, and protecting student athletes. The reason we are gathered here tonight is that we have all heard the word antitrust in college sports. And the reason for that is because NIL has been generated by applying antitrust laws. In the Alston case, a Supreme Court decision that was adjudicated just down the street from where we live. NIL is a movement as a result of that Supreme Court decision, and we are fortunate today to have a leading antitrust expert here with us tonight to talk about antitrust in college sports, how it applies now, and where it is headed. So I will let Rich Parker introduce himself, and we will get started. Welcome, Rich.
Thank you, Tara. I am Richard Parker. I am an antitrust lawyer in Washington, D.C. I'm with a large New York law firm, Milbank, but I'm in the D.C. office and I do all antitrust all the time. I do government work. That is, I deal with the U.S. Department of Justice and the Federal Trade Commission. I also try cases. And for 4 years, I was in charge of antitrust enforcement at the Federal Trade Commission here in Washington. So I'm a former enforcer. So tonight's topic is antitrust in collegiate sports. Where are we? Or how about this? Where, if anywhere, are we? Because we are just getting started. You know, stories have a beginning and a middle and an end. And this story is somewhere between the beginning and the middle. It started, as Tara said, with some litigation, and in particular, the Alston decision by the Supreme Court of the United States. There's a lot of things going on, and frankly, we don't know where it's going. So I'm sitting here trying to think about where, I'm going to call you folks the NIL community, because I think that's pretty much what you are, what the NIL community is thinking about right now. And I would think that you would be thinking about, where's all this antitrust litigation going? Is there really going to be $22 million or some number like that coming out of the House settlement that's going to be shared going forward? Is there really going to be $2.87 billion coming out of the House settlement for the past denial of people who should have gotten NILs? Where is Congress in all this? And what's all this stuff about collective bargaining in the NLRB? And these are the elements of the story that is developing. But unfortunately, I'm not going to be able to answer any of those questions. And I respectfully suggest that nobody can. Because as I've said, the story is still happening and we're going to have to watch it play out. But here's what I can do, and that I really hope it's helpful to you. You know, that Prime One is trying to do these educational seminars to get you up to speed on key issues. And so the best I can do in the antitrust area for you tonight, the best I can do is to go back to first principles and explain to you what the antitrust laws are. What are they? And how do they apply in this particular industry? And what are the issues going forward? So that you walk away from here, don't let anybody tell you that they know the answers to all those questions. And I've read in blogs and everywhere else, oh, I know what's going to happen. No, they really don't. Just trust me, they do not. This is a developing story, but I'm hoping that what comes out of this tonight is that you have a framework, a basic understanding of what's going on that will help you think about these issues and think about developments as they happen. And maybe a year from now, after there's some more water under the bridge, we'll have another one of these, and maybe there'll be more answers or more definiteness around the story. All right, so let's start. Antitrust. All right, and I tried jury cases, and this is what I tell juries about what antitrust is, okay? Antitrust is the law of competition, all right? And competition is what drives the United States economy. Our economy is based on a premise, and the premise is that people will get the best wages, will get the best products, will get the best services, and will get the best innovation if companies are basically clawing each other's eyes out and the marketplace trying to come up with the best product. I mean, I was just looking, I got some friends who are buying trucks and they're telling me, look at Chevy versus Ford versus the Tacoma versus Ram, and they are really slugging it out, and they're coming up with better product every year. They're coming up with more electronics, and they're competing on price, and that is how the United States economy drives. And let me tell you, folks, we have the greatest economy in the world, the United States. People want to invest in the United States, but when you invest in the United States and when you do business in the United States, you compete. So the problem is that some people think if I opt out of the competitive system, man, I can make a killing. I'll tell you right now. If I don't have to compete with a guy across the street, I can raise price, I can do all kinds of things. I will make a mint, okay? So there's three things that the antitrust laws prohibit, right? To make sure that that doesn't happen. One, competitors cannot agree not to compete. You know, they can't fix prices. They can't agree not to compete on credit terms or on anything like that. That's called collusion. And that's what we're going to be talking about tonight. But just for your information, there's two other major antitrust violations, and one is merging. Oh, you know, would I rather compete with the guy across the street or own him? I think I'm going to own him. Well, you know, the antitrust laws regulate that. And the Department of Justice and the FTC won't let you do an illegal merger. I know, because I used to go to court representing the government soon on cases like that, okay? And the third is, well, you know what I'm going to do? I am going to engage in predatory conduct. And I'm going to exclude my competitor, and man, I'm going to make a mint. That's called monopolization. And everybody knows that Amazon, Ticketmaster, Meta, Google are all sued for what? Monopolization. Microsoft got nailed 20 years ago. So that's the other type. But tonight, what we're talking about is collusion, is people agreeing not to compete, opting out of the competitive system. It's like two fighters who go out there and say, look, man, let's not really, you know, let's kind of go through the motions so nobody gets hurt and then we'll just go home. Well, that's not what you can do here, okay? You got to compete in the United States. So the other point here is the competition that's at issue here is competition for the best people. I mean, do you think that the oil companies, for example, could all agree, well, we're only going to pay petroleum, engineers X dollars. And so nobody has to pay anybody any higher. No, you can't do that. If every bakery in town says, I'm only going to pay bakers X number of dollars per hour, you can't do that. And here we have a situation where we have competitors, okay, schools agreeing on what they are and what they are not going to pay young men and women for being athletes. That is an antitrust problem. And that's what's being confronted now, and that's where we are. Okay, So let's go back for some history, okay? Football, I'm going to talk about, I'm a football fan, we'll talk about football. So football really started gaining popularity in the 1880s and in the 1890s, way back. And it was extremely popular at colleges all over the country. But they started developing a problem. 1 year, 5 young men got killed. 1 year, 12 young men got killed. And finally, in 1905, 15 men got killed. Why? Well, because there were no standards on equipment. They had terrible equipment. And because they allowed these crazy plays. Okay, when you finish tonight, okay, here's what I want you to do. I want you to Google something called the flying wedge. And that was a formation that was allowed in the 1800s and early 1900s in football. And that's where all the people got killed. That's no longer allowed, obviously, but just for your own interest, go look that up. It's based on, believe it or not, seriously, I'm a history buff. It's based on medieval army tactics, okay? That's what they were doing in football, and guys were getting killed. So what happened? President Theodore Roosevelt, one of our greatest presidents, and the first president really to be concerned about antitrust and similar issues was Theodore. He called the presidents of the key universities in the country together and said the American people are not going to tolerate a sport in which 15 guys got killed. I mean, it's just not going to happen. Fix it. And so that's where the NC2A started. That's where it started, outlawing the flying wedge, outlawing a bunch of other kinds of super rough tactics, and setting standards on equipment and doing things like scheduling. And the antitrust says, you know, competitors can get together and decide on things, but only where they are essential for the product. Okay. And what Theodore Roosevelt said, if you don't stop killing people, you don't have a product. And everybody realizes the American people are not going to tolerate that. So that's where the NC2A came from. All right. Over time, and during the first part of the 20th century, people were getting paid left and right. Left and right. I mean, they're getting paid under the table. They're getting paid by universities. There was no regulation on it at all. There was a guy who played for Washington Huskies. They called him Hurricane Hugh McElhaney. That's the Hurricane Hugh, great sports nickname. And he said that every time I scored a touchdown, money would be slipped under my dorm door. Okay. And he said, when I went to the 49ers, I had to take a pay cut. So that's what was going on. And so the NC2A said, look, this has got to stop. You're not going to have a product if there's not safety. And you're not going to have a product if the players are not amateurs. I'm not buying into this argument, folks. Well, we're going to talk about that later. But I'm telling you where it came from. They're saying, okay, what was, this happened in the 40s. What was emerging in the 40s? Answer, the NFL. It was starting to gain popularity. Red Grange, Bronco Nagurski, George Halas, and the monsters of the Midway, the Bears. So you had professional sports. And the NC2A said, well, if we have paid athletes in college, they're going to end up like what? Minor league baseball. And who gives a damn about minor league baseball? And so they came to the concept that what really makes football, college football, attractive as a product is amateurism. That the players don't get paid. They can get scholarships. Oh, yeah, you can get scholarships. They can get education-related things, but they can't get paid. They can't get something like an NIL. Otherwise, we will become like what? like minor league baseball, and we will sink into insignificance. That was the thinking. However, what is it? It is colleges and universities and conferences who compete against each other, who are agreeing, who compete for the best athletes, and they're agreeing on compensation. That's a big antitrust problem. Remember what I said. You're supposed to compete unless it's essential to have the product itself. So all this litigation started, and it was, you can't agree on wages, and the NC2, oh my God, you got to have amateurism or you won't have a product. So let's think about that. And, you know, when you're done, I want you to look up the flying wedge because it's interesting. But I also want you to think about, you know, what does make college football you know, such a great game, or the college basketball such a great game, for example. I mean, I watch football every Saturday. Why do I do that? And I think about it. Is it because they're amateurs? Nah, I'm not so sure that that's true. I don't know. I wish I could talk to all you people out there, but I don't know if that's true. That may be true. That may not be true. You know, I'm a UCLA guy, and we play SC every year, and it's the greatest game, and the stadium's filled, and it's totally exciting, and it's the Battle of Los Angeles. Do you think I'm going to change, become less interested in that because the students, I mean, the players are getting NILs? No, I don't think so. It's something else. That's what I personally think, but let's move on and see, you know, but that's going to be an issue in court. And everybody ought to think about that. Look, folks, okay, it is really a great idea to pay, you know, that athletes get a piece of all this money. I agree with that. But on the other hand, you got to have a product, okay? If you don't have a product that people like, you got nothing. And that was what the NC2A was concerned about. That's what they say in court, and that's what they were concerned about. Now, as I said, I don't agree with it, but it's not crazy. It's not crazy. It's not irresponsible to make that argument, and it's not crazy. Now, let's talk about some of these. There's a lot of cases out there, but the case that really got us going and that brings us together tonight is what? Alston. NC2A, Alston versus NC2A. Filed, Northern District of California, San Francisco, Oakland area. Judge Claudio Wilkin, excellent trial judge. And they had a trial, and Judge Wilkin found that, look, okay, the NC2A says that amateurism is important, all right? But that does not justify limits on educational related benefits. So if it's an educational related benefit, that doesn't destroy amateurism, and those are okay. But she did not say, and don't let somebody tell you that there was some big triumph in the Alston case for NILs. There wasn't. She never said that the NC2A couldn't ban NILs. And then it goes to the Supreme Court, and the Supreme Court didn't say that either. The Supreme Court didn't say that either. But they did say that the NC2A cannot restrict educational related benefits. Why? Because their reason for doing it is amateurism, and education related benefits do not destroy amateurism. But what else happened in the Supreme Court? Okay, that was a 9-0. Okay, nine justices on the Supreme Court. Obviously, you know, you got to have a majority. You got to have 5. Whoever gets 5 wins. And 9 all said that, yeah, that's right. Judge Wilkin was correct. But Justice Kavanaugh, who's a sports guy, he went to Georgetown Prep, a big sports school. I think he was a basketball player in Washington, D.C. area. But he said, look, I think that amateurism does not justify not compensating athletes, and that there's gazillion dollars coming in on NC2A. You know what? The March Madness itself is worth like $1.1 billion, and that players don't get a thing. And I don't think amateurism justifies that. And his view would be what I was expressing later, that the reason you love college football is not amateurism. I thought that he said in the opinion, game days in Tuscaloosa, game days in South Bend are not going to change if the athletes are compensated. And he rejected the NC2A argument on grounds that I just did a few minutes ago. But that's not the law. That's one vote. The way the Supreme Court works is Justice Kavanaugh said, hey, I have got this opinion, and I think that the NC2A is all wet on all of its restrictions, and I've laid it out here. Why don't all you folks join in my opinion? And nobody did. There's one opinion by Kavanaugh. And when you hear people in the NIL community going on and on and on about how the Supreme Court did this, they're talking about the opinion of one justice. You need 4 more to make a majority, and they don't have it. All right. So that's also an important case, though. I mean, Justice Gorsuch wrote it. I'm an antitrust guy. He's a brilliant guy. If he's from Colorado, brilliant guy. He's a sports guy. Okay, he loves sports, big time. And he wrote, in my opinion, a great opinion, and he was correct. So the plaintiffs, that is the Jeffrey Kesslers and Michael Hausfeld and Steve Berman of the world, who represent players and classes, said, I think the next time this is up in front of the Supreme Court, Justice Kavanaugh's opinion will prevail. That's what I think. So they filed all these lawsuits, and the NC2A is defending them again on the grounds of amateurism. But both sides have risk. Okay, the players could go litigate, say, the House case. That's the most important case called the House case. It's a case that would allow free-flowing NILs. And would allow damages for past the whole thing, okay? That is an important case. And the plaintiffs there, they say, well, I think the Supreme Court will go our way. And the NC2A, has their arguments, and they say, well, Kavanaugh was only one guy, maybe we can win up there. But they both have risk, okay? They both have risk. There is a risk on the plaintiff side, on the player side. I'm talking about the player now, that they go try this case and they litigate it for 4 years and get nothing, or a disappointing amount. And the NC2A, they could get a judgment against them for past NILs that would put the whole thing in bankruptcy. So they're both have risk. And so what happens when you both have risk? There's a settlement. There's a settlement. And so what has happened is that there's been some public discussion of the settlement. There's apparently a piece of paper that's got 13 key points on it. And one of them is the $22 million or the $20 million. And the other is the almost $3 billion for past NILs. And that is a compromise amount. And what they're now trying to do is put the details around this settlement. That's what they do, right? It's going to be a document that thick, folks, okay? And that's what they're working on. And that's hard to do, and that'll come out in about a month or so. And by the way, it is what's called a class action, because Berman and Kessler are representing a class of players, the people on this call. So that has to be approved by a judge. So we'll have it in front of us. It'll be on the public record, the whole document, and we'll be able to see it. But in the meantime, I suggest that people who are, excuse the expression, running their mouths about what they think is in that settlement, well, maybe it is and maybe it isn't, okay? Maybe, what you say about that, this is part of the story, Okay, this is a story where the rumors about the settlement come out. At some point, the settlement will come out, and then you'll be able to judge it. And so when you judge it, I want you to think about it as a settlement in which both sides compromise, right? Let's assume that a car is being sold for 20,000. And you say, well, I don't want to pay any more than 10. Well, guess what? You settle on 15, okay? Is 15 a scientifically determined number about what that car is worth? No, not at all. 15 is the lowest price you could get, and 15 is the biggest price that the dealer could get, and that's what it is. So it's gonna go 20. Oh my God, they only got $22 million. Well, this is not based on a scientific survey or anything else. It's based on the give and take of negotiations. And by the way, I know all these people. The lawyers on the player side are superb. The lawyers on the NC2A side are superb. These are really good people. And so when this thing comes out, don't think it's some pronouncement that 22 is the right number or 2.87 billion is the right number. It is a settlement. It's like negotiating a car at 15. You know, you don't want to pay 15, and the dealer didn't want to give it away for 15, but that's the best you can do, and that's what it is. And that's the way to think about this thing. Would you rather get 22 million or go to court for 3 years and get nothing? Or would you rather give up 22 million or go to court and maybe lose 15 gazillion dollars or something? That's what's going on here. That's what's happening right now. And that's why the story isn't finished. Okay. Now, I want to move on to one more. You know, yeah, there's cases all over the place. You know, we could sit here till Christmas Eve talking about this stuff. And I happen to like it, so I probably could, but that's not what we're going to do tonight. So what I'm going to say is this. There's another case that I think is important here. Okay. And I think it's very good for what I call you guys, the NIL community. And let me go back again. Okay, so somebody violates the antitrust laws. Okay, who goes after them? Well, private plaintiffs, you know, like the class actions that are involved in Alston and House and the like, go after and get damages. The Department of Justice, Antitrust Division can go after them, and the Federal Trade Commission can go after them, and all 50 states plus the District of Columbia can all go after somebody who violates the antitrust laws. Okay. I mean, you know, I represent company. I say, man, you do not want to get into an antitrust violation because they'll throw the book at you. You got all these people coming at you. And I used to be an enforcer. I used to, you know, do that piling on myself. Okay. So, good news here is that there was a case filed by the state of Ohio, and I think it was 6 other states, versus the NC2A. It was filed in Clarksburg Division in a federal court in West Virginia. Okay. Ohio v. NC2A. And guess who joined the suit? Answer: the Antitrust Division. The United States Department of Justice Antitrust Division, headed by a very strong enforcer who used to work for me when I was in the government, Jonathan Cantor. And he is very, very, very strongly behind the NIL community. And they joined this. So now you've got the Department of Justice on the side of the players. Okay. And that's why I'm mentioning it. It's significant. And did they do a settlement? Well, no, they didn't do a settlement. They did they got an order. Here it is right here. I'm reading it. And what it says is that the NC2A are permanently restrained and enjoined from enforcing the transfer eligibility rule. And so what they've done is the transfer portal has now been supported by the Department of Justice, and they have a consent decree. And if the NC2A or any school were to violate that, they would be in contempt of court. That is a very serious matter. And it's very good news for the NIL community that Department of Justice is involved, and very good news that they got a consent decree over in West Virginia. So I could go on. There's a lot more cases, there's all kinds of stuff here. There's one other factor, and I think that Prime One will have somebody come in at some point to talk about this, and that's collective bargaining. Okay, you ready for this? Think about this. A union is a massive antitrust violation. Okay, if all the mechanics in Washington, D.C. got together and said, we are not going to work for anything less than, X. That's a violation of the antitrust laws, except there is an exemption for labor unions. So that's where this collective bargaining stuff comes in, because we got a massive antitrust problem in college football, and there is an exemption. And if the players are employees and can form a labor union, then you can negotiate for that 22 million and maybe make it bigger than that. I don't know. Negotiate for that 2.87 billion and maybe make it bigger than that and have an exemption from the antitrust laws. One other point. If the House settlement comes through and there's this $22 million cap, okay, there isn't an exemption for that. And there is a possibility that once House is approved, okay, by the judge, we're not done. You may have to go to Congress and get an exemption for that settlement. And one of the benefits of going the labor route is, guess what? There already is an exemption. So I hope that this is probably clear as mud. I'm doing the best I can to explain this stuff, but this is not easy. And so I think what's going to happen is this. I don't think that you're going to know what's going to happen in House, this year. It's going to take a while. They're going to negotiate the deal. They're going to file it. There's going to be times for objections. There's going to be a hearing. Judge Wilkin will look at this seriously and write an opinion. That'll take her a while to do that. I think that'll go well into next year. Will there be a need for congressional action? Well, maybe there might be, and the lawyers are all already talking about it. I don't know, but this is going to play out for a while. In the meantime, NILs are definitely legal. The transfer portal is protected, and you ought to proceed one step at a time. And deal with the collectives and deal with the schools and deal with whomever you have to deal with, and then keep your eye on what's going on. And so my only advice to you would be to get some assistance from people who are actually following this and who actually know. Well, I'm not giving you, trust me, I'm not, you're not my client. I'm not giving you any legal advice. I'm just telling you what's going on. And I'm telling you, for your individual system, I think it's probably a good idea to get some help, because, as I said, we're about halfway through a story, and nobody, certainly not me, knows where this story is going to end and how you're going to deal with it. Now, I've said a lot of stuff. I hope this was helpful. Do we have any questions or something? Because I will respond to those as well. I'm, assuming I know the answer, right? Maybe I don't know the answer, but let's try.
Thank you so much, Rich. This has been really enlightening, and appreciate the historical perspective as well as, where we are now and where we're going. We do have some questions from the audience, so thank you for typing in your questions. The first question is, are all sports affected by this proposed settlement, or is it just football?
Not football, basketball, the whole thing. College athletes. All right. Yeah. I mean, it's all going to come out the same. If college football players can do NIL, so can volleyball players. That's what's going to happen.
Okay. And next question, do I need to have an attorney for representation? If so, why?
Because this is really hard. I hope I explained it as best I can. Right now, there's all kinds of state regulations. You gotta comply with, and going forward, at some point, there's gonna be a settlement in house, and you want to take advantage of that. And you want to make sure that you're dealing fair and square with these collectives and other people who are passing out the NILs, to make sure your eligibility isn't affected, and to make sure, you know, you're dotting the i's and crossing the t's. I mean, this is unfortunately a complicated and developing area, and you need to be involved with people who actually know what they're talking about, and who are keeping their eye on things and watching this story unfold. Because as I said, this is a story right now.
And how long could this story take to unfold? What is the longest time frame, do you think we're looking at?
I think it could easily take 2 years, and maybe I'm being optimistic.
So it's a long time.
It's a while.
Okay. If there is federal regulation on NIL, what happens to the state laws that we have now?
I'm guessing, but I think that most of the bills would preempt the state. The federal, under various circumstances, can preempt state law and say the states are out of action here. This is a federal problem. And think about it. I mean, this is not a state problem, okay? You got a young man who grew up in Indiana who's playing football for UCLA. I mean, so this is a state problem, and this is an interstate problem. It's a national problem. And so my guess is Congress is going to say this, we're going to regulate this at a national level.
Okay. Well, I think the last question is, what happens to the NCAA when all of this is said and done?
It depends, you know, they may exist. I mean, they may be back regular, you know, nobody on this call, I would think, I wish I could talk to you, would think that they shouldn't be regulating safety, that, you know, they shouldn't be eliminating the flying wedge, that they shouldn't be you know, mandating better helmets and equipment. So, you know, I think they'll be doing that, but whether they'll be involved in anything having to do with compensation or something is, you know, I mean, it's not going to be the same, folks. There's no question about it. NC2A will be, I think it'll be excellent, but it'll be much diminished over what it purported to do in the last few years.
We keep getting questions.
Good.
So, do all athletes get a piece of the settlement, meaning financial?
Yeah, well, you know, okay, so here's what's going to happen. All right. So there will be a class that will be defined. And say for the damages class, it'll be everybody who played college sports for the last 4 years, which is a statute of limitations, or gets a piece of the $2.87 billion. And that all depends on what the settlement will define who gets a piece of the action. And the judge will decide whether that's fair. So the answer is, I think it's going to be something like what I just said, but you know, what do they say? Stick around and find out. That's what I'm doing. This thing will be filed publicly, maybe before the end of the summer, and then we'll all know.
That's great. Well, Rich, we want to thank you for being here. We want to thank you all for joining us. And again, Prime One Sports really supports education, and we want to be the source of good information for you. If you've got questions after listening, please do reach out. We have a website, www.primeonesports.com. We would love to hear from you. And again, look for us. We're going to be doing a series of educational seminars with experts on this subject, and we look forward to convening another time. Thank you, Rich, and have a wonderful evening.
Thank you.
Thank you all
for having me. Good night, everybody.